the Banyan case, I'm not sure, I know it was not good enough, whether he took you to paragraph 33 in the Banyan decision. So could I just take you to that, if I may? You will find it behind tab 22 at page 11 of the judgment. Yes. And what the Court of Appeal said in Banyan was, once service is effected, the court must recognise the award. The only grounds for refusing recognition are set out in Article 44 of the DIFC arbitration law. These are exhaustive. There is no basis for contending that enforcement of a domestic award has any additional jurisdictional threshold requirement. So I think, with respect, that he was not correct in submitting that there is a discretion as to whether the court recognises or enforces an award if all the other conditions are met. There is certainly a discretion, as we see in the next paragraph, in relation to execution, but that is an entirely different matter. If, therefore, there is no discretion as to recognition and enforcement, that in many ways is the end of his submissions. And we would say that everything that followed was really nothing to the point. But Mr. Reed spent almost all his time yesterday on the alleged defects in the award. You will, no doubt, have noticed that he did not try to link any of those alleged defects to any grounds for challenging recognition and enforcement under the DIFC arbitration law. His submissions were based upon what we say is a novel doctrine that the court will not exercise discretion unless the claim satisfies some undefined concept of substance. Since there's no discretion, that falls at the first hurdle. But even if it didn't fall at the first hurdle, it is, in our respectful submission, unsustainable. Indeed, if a court is faced with a weak claim, it exercises its discretion and it strikes out or dismisses the claim. It's simply not a reason for not exercising its jurisdiction that the claim is said to be weak. But there is no support in the DIFC authorities for this idea of some threshold substance qualification to the exercise of jurisdiction. My learned friend pointed to two cases, neither of which in our submission support the point. The first is the Hart case, and could I take you to that in bundle A1 at tab 28. And if I may, I will take you straight to paragraph 60 at page 18 of the report. And in that case, the court rejected jurisdiction on these grounds. 60, this total absence of any specific allegation against the first defendant is, in my judgment, important. If a claimant fails to make any coherent allegation against a centre establishment, although the party may be joined as a defendant, he is not a party against whom the claimant raises a case which can found a dispute. All he has done is put a name on a DIFC court's claim form and nothing else. In these circumstances, no dispute involving that defendant has been properly identified, and the DIFC courts do not have jurisdiction under Article 5A1 to do more than strike out the claim against this party. Where there is no formulated claim, there is nothing that engages the court's jurisdiction. And so indeed what the court was holding there was not that we look at the merits of the case and decide whether there are sufficient merits for us to exercise jurisdiction. What it was saying there was that its jurisdiction is not engaged at all because there was no claim which could be subject to the jurisdiction. May I then take you to the Harafi case, which is slightly more complicated, and that is in the next tab, 29, And can I take you to page 19 and begin reading at paragraph 72? Without deciding whether Saracen Dubai were agents in the strict sense of being clothed with authority from Saracen Switzerland to create privity of contract between the latter and the third parties, we find there is at least a good arguable case that they were employed by Saracen Switzerland to market its investment products. There is no evidence of the internal group terms on which Saracen Dubai acted in that capacity. However, we infer from the conduct of the Saracen Dubai personnel involved and their apparent system of instant contact with Saracen Switzerland that they were employed as nominally independent but in-house marketing organisation. In that capacity, as an independent contractor, their conduct in relation to the marketing of these products could not give rise to vicarious liability of Saracen Switzerland in the strict sense. However, if their defective conduct had been specifically authorised by Saracen Switzerland to the effect that the misrepresentation and the non-disclosure of risk were specifically authorised, Saracen Switzerland could incur liability as a principal tortfeasor whose tortious conduct had been delegated to Saracen Dubai. That would be the position under English law. There is, however, no evidence as to the position in Swiss law which could apply if the law and jurisdiction clause were binding. Accordingly, on the hypothesis, it is permissible for this court to presume for present purposes that Swiss law is the same as DIFC in English law, and on that basis conclude that the claim against Saracen Switzerland is shown to have sufficient substance for this court to exercise jurisdiction, provided that one of the jurisdictional gateways is engaged. On at least that basis, we conclude that Article 5A1C gateway is engaged, and further, that the wording of the claim form as amended is sufficiently wide to accommodate such a claim. And the real answer is in that paragraph 75. What the Court of Appeal there was doing was not looking at the substantive merits of the claim. What it was doing was looking at whether or not there was sufficient substance in the allegations that would give rise to jurisdiction. So the threshold question was not, is this claim good enough for us to exercise jurisdiction? The threshold question was, as it always is in a jurisdiction case, is one of the gateways engaged? And that's exactly what they found in their analysis. At paragraph 75, we conclude that Article 5A1C gateway is engaged. And it is to the engagement with the gateway that any question of substance relates, and not to the substantive merits. And so we say that this novel theory that before the court exercises jurisdiction it has to look at the merits of the case just doesn't get off the ground at all. And the English cases don't help because it's an entirely different regime in England. In England it is necessary under English procedure to show that there's a serious issue to be tried on the merits of the claim. There is no such obligation under DIFC procedure, and indeed we set out why we say DIFC procedure is different, which is not perhaps strictly necessary, but what it does lead you to is the point that because of the differences between the nature of the jurisdiction in the DIFC, in that it's an international jurisdiction and therefore it has been decided that you don't need permission to serve out of the jurisdiction as an exception, but rather that the dispute against jurisdiction is the exceptional case. You're rather in the same position under the DIFC when it comes to procedure, when it comes to looking at substance, as you are under the domestic jurisdiction of the English courts, where they are dealing with the unexceptional circumstances. And we say that in neither case is it appropriate to look at the underlying merits of the substantive claim. Because the usual situation in both jurisdictions is, if it is a claim that is not of substance, it will be struck out, or there will be immediate or summary judgment in this jurisdiction under RDC Part 24, and the claim will be dismissed. And so we say there is no basis in the IFC procedure for any new doctrine of there having to be a sufficient basis in terms of merits for the court to exercise a jurisdiction. And there is no need for the court to be drawn into a consideration of the merits of any challenge to an arbitral award. Indeed, we would say not only is there no need for a court to be drawn into an analysis of the merits of an award which is before it for enforcement and recognition, it is not permissible for the court to review the merits of an arbitral award on an application for recognition and enforcement. And we see that in, again, Banyan Tree, at paragraph 32, where we were a moment ago. On page 11, that the court must recognise the award, and the only grounds for refusing recognition are those set out in Article 44, and they are exhaustive. And those grounds do not include any analysis of the underlying merits of the award. But even if I'm completely wrong about all of that, then even on Mr. Reed's theory, there must be a good arguable case. We are a party who has the benefit of an arbitral award. We are seeking to enforce that arbitral award. It cannot be said that a party that is in possession of an arbitral award does not have a good arguable case that the award should be enforced. What he is saying, and all of his submissions were directed to, was that he has a good arguable defence to enforcement. And whether he's right or wrong about that, that is a very different thing from saying that WCT has no case of substance sufficient to engage the jurisdiction of the court. And so, what it does show is that even on his own test, there is sufficient substance to engage the jurisdiction of this court. What he demonstrated, we say graphically yesterday, in spending 2 hours on analysing the award and making his case that the award should not be enforced, is that this is indeed a very substantial matter, and that this is indeed something that merits the attention of this court. And essentially, I would say that those 2 hours that we spent yesterday were really no more than an excuse to go on a impermissible excursion into the merits of the award, which is not a matter which is permitted on an application for recognition and enforcement under the DIFC arbitration law. Turning then to the first ground, namely that the award is being challenged before the Dubai courts, this cannot, in our submission, be a reason for the court to decline jurisdiction. It could be a reason for the court to adjourn recognition and enforcement, as we said, under Article 44.2 of the arbitration law. But again, of course, Meydan has specifically said it is not seeking to adjourn recognition or enforcement, and it is said that its application is made under some other basis. But it can't escape what it seeks to escape from, even if the court does suspend or adjourn its proceedings. If the court were to adjourn or suspend its proceedings under Article 44.2, it would have power of its own motion to order the provision of security for any adjournment. And we see that from an English decision of the Court of Appeal, Dardana and Yukos Oil, which you will find in our bundle, the blue bundle, dark blue bundle, at tab 17.
Yes. Which paragraph?
It is, if you will forgive me, paragraph 31 at internal page 366. Sorry, I'm just struggling with the bundles coming apart.
Yes.
Where it's said by Lord Justice Mads, as he then was, I am fully prepared to proceed on the basis that Section 1035 provides the court. 1035 is the identical section to Article 44.2 of the arbitration law. Section 1035 provides the court with jurisdiction to make such order in a case where it, either of its own motion, as in Sole Bone, or at the instance of the party seeking recognition or enforcement, decides to adjourn pending a foreign application to set aside by the party resisting recognition or enforcement. And of course the use of the word foreign there is in the context of a New York Convention application. Of course in this jurisdiction there is no difference between a foreign application or an application from outside the IFC, but not from outside the UAE. So that would be if it was under 44.2, but there is a general power in any event, which was considered in the IPCO case that we referred to before, and there is a second judgment in IPCO which I think has probably been put behind the same tab 6 in the no, it hasn't. No, it's behind tab 22, I'm sorry, the second IPCO. The Court of Appeal did something rather odd in the IPCO case. It issued two judgments, supplementary judgment. This is the supplementary judgment. And you'll find it behind tab 22. It's been put behind Mr. Justice Gross's judgment rather. So if I could take you to it's internal page 38 at paragraph 6. And at paragraph 6 it quotes Lord Justice Mads in Dardana, and then under the first column on page 38 it says, it's not wholly clear to us how Section 1035 was thought to provide jurisdiction to the court to act of its own motion. But in any event, a court which is asked to adjourn or continue an adjournment of enforcement is entitled to impose conditions in the exercise of its discretion to do so. And there is there reference to CPR 3.1 and may do so of its own initiative under CPR 3.3. The equivalent positions to the the equivalent provisions to the English CPR are RDC 4.2 and 4.3. They are the same. And so it's clear that whether or not there is an adjournment either under 44.2 or an adjournment for the purpose of allowing an application to be made to the Union Supreme Court, this court does have jurisdiction to impose conditions upon it if it considers that it's appropriate. And so in such circumstances, if this court were minded to adjourn on either basis, we would ask the court to impose the condition that the full amount of the award be paid into court. So that's why the court, the allegation as to why the court should not exercise its discretion. I move on now to the final point, the alleged non-disclosure. This point has somewhat changed on at least two occasions, from the evidence through to the written submissions, and then finally through to my learned friend's very succinct and focused submission that he made yesterday in relation to the original claim of non-disclosure, and I'll deal with that first of all. And then there is a second claim of non-disclosure, which I called the ambush claim before, which I'll come to right at the end of my submission. First of all, as to the narrow way, the very narrow way in which my learned friend put it in his oral submissions, that he referred to a letter that was written by his instructing legal practitioners, and you will find that in bundle B2, tab 13. And it's necessary that we look at that and establish the chronology of what occurred. So, if you'd be kind enough to turn to page 371, which is the first page behind tab 13 in B2. We need just to get the dates here. So this letter is dated 6th August 2015. And we see at paragraph 1.3 that the final award was issued on the 5th of July 2015. So we are some, I think, 29 days or so after the award was published. And we then go to paragraph 1.7 of this letter on the next page, page 372. And it says DIAC Rule 338.4. As I said before, when I was talking about the DIAC rules and the binding nature, I said, you may recollect that I said before the short adjournment at lunchtime that Meydan had relied upon the DIAC rules, so there can be no issue that they apply, and indeed here is the reliance upon DIAC Rule 37.5. 38.4, I'm sorry, where it says DIAC Rule 38.4 makes provision for a tribunal upon request of a party to make an additional award in respect to claims not dealt with in a final award as follows. A party may, within 30 days of the receipt of the award, by written notice to the tribunal, with a copy to the centre and other party, request the tribunal to make an additional award in respect of claims or counterclaims presented in the arbitration but not dealt with in any award. Before deciding on the request, the tribunal shall give the parties an opportunity to be heard. If the tribunal considers the request to be justified, it shall, wherever reasonably possible, make the additional award within 60 days of the receipt of the request. Can I then ask you to go forward to page 377 and paragraph 7, 1.17. Finally, the tribunal's attention is drawn to the mandatory requirements of the DIAC rules. Under DIAC Rule 38.4, that before deciding on the request to make an additional award, as noticed at 1.12 above, the tribunal should give the parties an opportunity to be heard. And B, DIAC Rule 28.1, that if either party requests, the tribunal shall hold a hearing for the presentation of evidence by witnesses, including expert witnesses, or for oral arguments, or both. Emphasis added. If we then